Does anybody have anything they want called more quickly before we get into Davis?
Can't do anything.
I'm
sorry.
No, you're okay. All right, let's call page 6, Wayne Davis, C377407.
Tupac and his mother and Uncle Tuwack Manor, they reside in Stone Mtn, Georgia. You know what I mean? And, you know, it should be a wanted reward out for the dude to bring him back to Nevada and Manhattan for that rape case. He got an appeal trial waiting on him. So,
thank you, Your Honor. To begin with,
I don't think these prosecutors is dumb, but they are ignoring the truth of the matter. And the matter is Tupac is not dead.
Against Mr. Davis solely based on his admissions. And if they don't have any evidence to corroborate those admissions, the case should be dismissed. And it's very clear, we both cited to the same exact case. That was the Sheriff v. Dada case. And the law is very clear that we cannot have just the confessions, because if you just leave that to the jury is going to just assume guilt because he confessed. And so without the state providing any evidence outside of those confessions, that's a huge problem. It amounts to a legal trial, a trial that won't have the correct result. And so the state is saying that basically we were, we should have done this as a habeas petition. I disagree with that. Here's the reason why. We are not contesting probable cause. What we're contesting is, after all of the evidence has been delivered, there's no corroborating evidence. There's nothing. And then the state also stated that we're just looking for a corpus delicti, you just have to look at the body. If there's a body, there's corpus delicti. And that's just not the rule, Your Honor. There has to be, obviously in this case, a body, but the state has also alleged that this was assisted, promoted by a gang. And so those facts have to be evident. And the only way we have those facts is from Mr. Davis's own mouth. The other participants in this, which I'll talk about in my second argument, are all dead. And so, but for Mr. Davis speaking and giving those statements, there is no corpus delicti in this case. I'll go to argument 2. And that's Mr. Davis's right to a fair trial and due process. The state pointed out the correct standard of review for that, and I don't disagree with that standard. However, the part that we disagree with is whether Mr. Davis is prejudiced or not. They're saying, well, the witnesses that died are going to give speculative, well, it's speculative as to what the witnesses would say. In those cases, yes, that would have been the situation. In this case, it's different. I'll just concentrate on these 4 witnesses, Your Honor. Eric Martin, and just for the court's edification, Eric Martin was the person that supposedly gave the gun. DeAndre Smith, who was in the backseat. Terrence Brown, he was the driver, and Orlando Anderson was alleged to be the actual shooter. Without these 4 co-conspirators being alive, being available at trial, basically Mr. Davis is completely prejudiced from proceeding. And his defense is he made this all up for profit. These individuals, these co-conspirators, have to exist in an effort to kill Mr. Tupac Shakur. If they're not alive, if Eric didn't give him the gun, if DeAndre wasn't the driver, if Orlando didn't shoot, we don't have a murder according to the state's theory, which is following, again, solely the admissions. So we go back to when was this information available to the state? I would allege that it was available all the way in 1996. Everybody knew Orlando Anderson was in a fight with Tupac. Well, he wasn't in a fight, he got beat up by Tupac and other members of his gang viciously. He was the #1 suspect right off the bat. There should have been an alert. The police should have been searching for Orlando Anderson, but we always knew where he was because he went back to LA. They could have been in contact with him. They could have gotten statements from him. They could have gotten statements from Mr. Davis. They could have gotten statements from Mr. Martin. They knew all of these players way back in 1996. I don't know what happened. I'm sure Mr. Giacomo doesn't know what happened in regards to why the district attorney's office did not proceed with prosecution or at least an investigation at that time. But it's a tactical delay that goes severely against my client because now all of these players are dead. I'll fast forward all the way to 2009. In 2009, the Metro officer comes down to LA and gives us, Mr. Davis gives the statement. That statement, all of the elements of this murder and what the state will attempt to prove at trial if the trial goes forward, is what Mr. Davis had said. They had that information. They did no investigation. At that time, Eric Martin was still alive, and also Terrence Brown was still alive. Orlando had passed in 1999, and I think DeAndre Smith in 2005. But at least two major players in this co-conspiracy are past. The DA's office, again, does not do any investigation beyond that. And so, with that, we feel that my client's sufficiently prejudiced beyond repair. It leads me back to the immunity argument. In 2009, I counted, well, I'll just go through the pages, Your Honor. In that 2009 discussion with the Las Vegas Metro Police Department's officer, Detective Long, on page 3, he says, no intent of arresting Keefe. Page 11, I'm not here to arrest you. I'm not here to arrest you. I'm not going to arrest you. Page 12, you're free to leave. I'm not going to arrest you. You can go wherever you want. Page 103 and number 4, Terrence Brown was still alive, and the detective said I was not going to arrest him. Page 134, I want to close the Tupac case. Page 138, this is confidential and covered, and you cannot be charged on it. Basically, you have the state was given the information by the LAPD. The LAPD had a immunity agreement with him out of the 2008 confession. The 2009 confession came by a product of Detective Dupree. Detective Dupree set that up. The only reason he set that up and why my client would have agreed to was that everybody was on the same page, that immunity was going to be provided. If it wasn't, how come he wasn't arrested right then and there? Because he said, I got the gun from Zip Martin, we were in a white Cadillac, I handed it to the back seat, and then Orlando took the gun and shot Tupac. All of that information is back there in 2009. But again, the DA office, and again, it's not these players, it's not Mr. Wolfson or Mr. Giacomo. That decision was made back then not to proceed with the trial. And now it's the state's burden, we believe, to show why they did not go forward and prosecute. They just can't sit here and say, well, he kept talking about it. no, you had that information in the beginning. You should have arrested him back in 2009. And so it had to be for a tactical advantage. That being, everybody's dead. It leaves Mr. Davis on the hook, and then he can't answer for all of the statements he made after that, other than it was for profit. And so,
Mr. Arnold, regarding the timeline that you've laid out,
yes, Your Honor.
would Mr. Martin and Mr. Brown have been alive after the Compton Street Legend book was published, or no?
What is that, 2018, right?
19.
2019, no, Terrence Brown dies, I believe, in 2015, and Zip Martin, I don't recall exactly when he died.
But it's not your argument that he ultimately would, if that's the state's triggering event for starting to investigate, that he would not have been alive at that time. Is that accurate?
After the book, right, when the book was published.
Yeah.
But after the 2009, he was still alive.
Of course, the Detective Long interview, of course, they're still
Right.
alive, but except for Mr. Anderson and Mr. Smith. Okay. I just wanted to make sure I had made it.
Yep. And outside of any other questions, Your Honor, I would submit.
Okay, thank you, Mr. Arnold. Mr. DiGiacomo, anything you want to add?
Just briefly, as it relates first to corpus delicti, that's death by criminal agency. Obviously, Mr. Shakur didn't shoot himself, so that is satisfied in a homicide by proof of the facts and circumstances, which were testified to, by the way, at the grand jury. And it is an argument. We didn't go through all of the evidence that is potentially out there. Their argument is there was insufficient evidence presented at the grand jury in order for them to be held under the corpus delicti rule. Even if you were to take it a next step further and say you have to have some evidence of a conspiracy independent of the bullets in Mr. Shakur, there's clearly at least a driver and a shooter, so evidence of a conspiracy exists. And so therefore, corpus delicti is satisfied no matter how you look at it, one way or the other. I also would dispute there's no independent evidence to corroborate, but that's not relevant in a corpus delicti argument. Corpus delicti is about criminal agency, and there's clearly criminal agency in this particular case. As it relates to the second argument, I'm unclear exactly what their argument is on the tactical decision we made. Their argument is he fully confessed, which as the court reviews that transcript, you can tell that he is being a knowing spectator all the way up until Dan Long gets kicked out of the room. Then his lawyer and Detective Dupree have a conversation where his lawyer tells him, hey, if you say the wrong thing, this guy can arrest you. And as you well know, because they're in California, Dan Long can't arrest him. Dan Long has to come back here, submit a warrant for his arrest, and take him into custody. Detective Long never tells him that he has immunity, but even if he did, all that would go to is the admissibility of the statement. Because Detective Long doesn't have the authority to issue that, nor do the LA DAs or the LAPD or the federal government. Only a court in the state of Nevada could say Mr. Davis has immunity from the crime of murder in the state of Nevada. And he has pointed to zero evidence whatsoever of any immunity. He has referenced some proffer agreements that he had with other agencies, and certainly that can be the subject of future litigation as to which of those statements are admissible or not admissible. And then the other, I guess, argument is somehow we waited intentionally so everyone else would be dead to charge Mr. Davis with a crime. No, Mr. Davis chose upon himself to publicly confess to a crime multiple times. And that's the evidence that spurred the investigation of Detective Mogg and ultimately resulted in his arrest. Mr. Davis has no basis to complain that he's sitting in that box right now. Because Mr. Davis got up there and even quote once said, I think it's in May of 23, on video, I beat the streets, I beat the feds, and I beat cancer. That was his choice to make. And when he made that choice, the state of Nevada chose to charge him, and he needs to stand trial for the charges, and I'll submit it.
Thank you, State. Mr. Arnold, any
Yeah,
follow-up?
just a quick rebuttal. I don't want the court to get hooked up on this corpus delicti. The corpus delicti rule is basically, again, that's in the preliminary hearing stages of the case. The black letter law is this. The law states you cannot have a conviction based upon just his admissions and statements. That's the law. If the state at this point puts on a trial to a jury and that's all they have is his admissions, that whole trial is illegal. That's a legal trial. It's going up for appeal. It should not happen. They need to have something else, a gun, a witness, something else that puts this gentleman, those 3 co-conspirators in the car. They need to have a witness to say that the gun was given to, from Mr. Martin to Mr. Davis. They don't have anything. They don't have anything to even prove that my client was in the state of Nevada at the time of this incident. I mean, basically, they have Orlando Anderson, but we don't know if the Crips were here. That's all hearsay that came from the grand jury, and there's no evidence whatsoever. And so without that, we can't put on the trial, Your Honor. We just simply can't. In regards to the delay, again, I don't blame this office, this DA's office in regards to the delay, but somebody made the decision along the way that we are not going to prosecute Mr. Davis. And this office now needs to go forward with that immunity agreement. They need to. Those promises were made by their officer, the state's officer, and now we're just going to ignore that? That doesn't make sense.
Immunity agreement from this office, or from the general...
From the general immunity that started from 2008 and went to 2009. Like I said, the only reason that...
Who within Clark County DA's office made that argument? Was that...
No, it wasn't at the DA's office. It was the Las Vegas Metropolitan Police officer, Detective Long.
When he said things like, I'm not going to arrest you.
Right, right. And again, like I said, it was not the office. And so outside of us, having an evidentiary hearing as to who made those decisions back then in the DA's office, I mean, my client is just prejudiced because of those decisions. Because, again, everybody waited all these years, and now we have players that are co-conspirators that are just dead and can't, deny participation. And so, with that, we submit, Your Honor.
Thank you so much, Mr. Orno. Okay, I'm going to take your arguments in turn. First, the corpus delicti argument. I am going to consider this on its merits, given the Supreme Court's guidance in Diami v. State. I think it's better to at least hear it on its merits. Corpus delicti requires that there be corroborating evidence to support a confession. In a homicide case, the Nevada Supreme Court, as you both said, indicated this would be satisfied by proof of death by criminal agency. So I think maybe an example makes the most sense to explain what this concept means. For example, I confess that this morning, as I was driving into work, I killed someone on 3rd and Lewis Avenue. All right, now let's say there's no body ever found, there's no video, there's nothing. It's only my statement that I killed someone that makes this crime exist. However, here, that is not, in this case, that isn't the case. There is corpus delicti because Mr. Shakur was shot and eventually passed away from his injury. An autopsy was completed. His death was determined to be homicide by gunshot wound. And ultimately, it's a situation where the crime has been established. That the murder occurred because of the body of Mr. Shakur. So I will deny it on those grounds. Regarding the pre-indictment delay argument, as you both cited, it looks like the standard that's laid out federally in People v. Nelson. I'll use that standard. A delay in prosecution that occurs before the accused is arrested or the complaint is filed, so we're looking at a pre-indictment delay argument. That could potentially constitute a denial of the right to a fair trial and due process of law under both state and federal constitutions. And then determining whether prejudice to the defendant has occurred, the court needs to balance the harm to the defendant against the justification for the delay. Here, it's clear that some of the witnesses are now deceased, and there is definitely evidence that has been lost. However, I do find there is a justification for the delay, and a pretty significant one. Uncovering information on Mr. Shakur's murder was ultimately no easy task. There was the interview in 2009, but it's clear that there was, at the attorney's suggestion, Mr. Davis at that time was not giving full information. He was sort of trying to obscure information and make it very general so that he would not be charged with murder, as his attorney indicated. It was not until ultimately the Constant Street Legend book was released in 2019 that Detective Mock then sought to establish the words in the book are actually defendants and to corroborate those things. The prejudice of the death of those 4 individuals that have been identified had already occurred at that time. Additionally, it took the next several years to gather that evidence and ultimately led to the June 23rd, 2023 search warrant of the defendant's residence. After that search warrant was executed, then the grand jury indicted the defendant after several meetings in September of 2023. The defendant has not provided any evidence to establish that the delay was intentionally done to gain a tactical advantage or that the prosecution delayed in bad faith. I don't see that the state really does gain any sort of tactical advantage here. I still think, it's a bit of an uphill battle for them given what they have. And ultimately, they can't get complete justice for Mr. Shakur because of the deaths of those other people, including Mr. Anderson, who's the alleged shooter in this incident. And so I ultimately don't see that this is a situation where the state really got any advantage by delaying, and in fact is themselves hindered. And so overall, I'm going to deny on the pre-indictment delay argument and turn to the immunity argument. It's fairly clear that the state of Nevada has never offered the defendant any sort of immunity. The federal government did in some capacity, but it doesn't appear to be complete transactional immunity. The court agrees that the interview defendant gave to the federal authorities in 1998 cannot be used against him as per the terms of the agreement. I think that's something that the state also conceded in their motion. However, the defendant has not produced any sort of agreement showing the federal government offered him transactional immunity from ever being prosecuted for this crime. In the 2009 interview that's been referenced multiple times throughout these arguments, Detective Long's assurances of not arresting Mr. Davis really go to whether he was in custody for purposes of Miranda or things like that. Additionally, he didn't have a warrant at the time, so that was an accurate statement of the law. There's nothing in that that can imply transactional immunity. Additionally, his defendant's attorney's at that time of that 2009 interview with Detective Long kind of show the opposite conclusion, that he is concerned with the defendant being charged with murdering Mr. Shakur, and that which leads me to believe that Mr. Davis did not have transactional immunity in the view of his attorney, and that's why his attorney advised Mr. Davis to keep it vague. And at that time, Mr. Davis did listen to his attorney, but his subsequent interviews and his self-proclaimed biography did not keep it vague. As the years passed, Mr. Davis revealed additional information on his own volition, and presumably for his own pecuniary interests that connected him to this, the alleged death, or the death of Mr. Shakur, allegedly at Mr. Davis's hands. And I do find the state is entitled to use that information freely given by defendant with no prompting by governmental authority and released to the public in its prosecution. So I'm going to deny the motion on that grounds. Overall, the motion to dismiss is denied, and the state is prepared the order consistent with this ruling and with its opposition.
Thank you, we will.
All right. Regarding trial readiness, where are we at with that, Mr.
Can we approach her?
Of course, yes.
Give me 1 second to go off on the
We'll lose.
Mr. Davis does want to speak to Mr. Arnold. I'll give him an opportunity to do that. If you need to recall, please let me know, Mr. Arnold. However, regarding trial readiness, Mr. Arnold indicated that there were potentially some issues that could prevent this case from going forward on 317. I'm going to hear those issues further on 211.
All right.
So we'll see everyone back 211 at 9 a.m. for status check trial readiness.
All right, thank you.
Thank you.
All right, thank you.
It would be okay if we call.
Listen,
Hey, yo, this some bull stuff. They trying to convict a man of murder. trying to convict a man on murder when the person isn't even dead.